Hello. Thanks very much for joining us on this webinar, where we're going to look at when AI becomes a data breach. And during this webinar, we're going to talk about the case law that's impacting lawyers when it comes to AI, and particularly how fee owners might be dealing with AI and not even realizing the implications. Then we're going to look at the fallout as to what might happen if that is happening in your offices at the moment, and then talk about the solutions and how that the future with AI is actually a really positive place where it should emphasize and support what the human is doing as opposed to taking over everybody's jobs. So here we go, let's crack on. The key question here is not about whether or not we should use AI or not, because what's actually happening in practice, and the case law proves this, is that AI is being used whether we agree to it or not. So as leaders in our industry, we're concerned over what somebody is doing. And the issue there is that AI is just spurting out anything. And certainly that's what's happened in practice with some of these cases. But the issue you've got is, are your handlers using AI almost with your consent or even behind your backs that's increasing their output so that you're really kind of bought into the fact that, oh, actually, AI is great because it's speeding them up, not realizing the implications of what might be happening when you upload some personal information to ChatGPT or the like. So remember, it's not about whether or not you're using AI. It is already being used. What's your controls? The key point that I really want to stress during this webinar is that this is just, or could just be, one pasted client document that can breach confidentiality and waive privilege. And that means that any document with any personal information on relating to your customer could just create you a whole wave of issues. And we're going to talk about what might happen with the reporting later in the webinar. And the issue here is not that AI might hallucinate. That's not the issue. AI does hallucinate. You know, if you've not got boundaries in place, there are hallucinations. The issue here is that the act of uploading is the breach. And just uploading, as I stressed, anything with the customer's personal information on is a breach, a data protection breach, and you are potentially opening the door to that breach if you are not fully locked down as to what goes on when you do so with your AI. So the first ruling that we're going to look at is one that was essentially created by the regulator. All right. Now, this specifically mentions ChatGPT, and we'll talk about other AI products as we go through the webinar, but ChatGPT is possibly the one that most are using and just dropping in, how should I respond to this letter? What should I say to the client when they've got this information? Seems dead straightforward, but in reality, that is a breach. So be careful. And the court on this one said to put client documents into ChatGPT is to place this information on the internet in the public domain, and thus to breach client confidentiality and waive legal privilege. That last bit of that sentence is an even bigger issue, because if you're mid-claim, you've issued proceedings, you've got some documentation, query whether or not you should be disclosing that documentation. If you upload that documentation into ChatGPT, it then becomes a disclosable document because it's in the public domain. So if you've got handlers who are looking to ChatGPT to advise on next steps on a claim or how to react to this defense, knowing this information, all of a sudden you've waived your legal privilege to that documentation. And irrespective of whether or not you breached the client confidentiality, that's now a disclosable product that could blow the claim out of the water. So you are in this position then when you're going knocking on your legal expenses insurer's door saying, I've got a potential claim here, help. The trouble is, of course, that anyone with access to Google has access to AI. And this is where you kind of like, I can't lock this down from my fee earners, from the handlers, because if I try and lock it down, that means I take complete access away from the internet from them. So you're in this position where you might assume that staff are not using AI, but if you've not been through the proper training with them so that they understand this is what happens when you upload this document outside of the agreed parameters that we've got within the company, then you are providing this access to anybody in the team, whether that's your admin team, your support team, your senior fee earners, the partners in charge, AI analysis that's being asked of by your data team. Anything there could be uploaded and would be a breach. And the thing is this statement in this hearing cannot stress it enough. It doesn't matter whether it's been inserted by a hapless trainee or by ChatGPT, the qualified legal professional with conduct to the matter is expected to ensure that only accurate documents are sent. So you're in this position where if you've got, as the partner in charge of department, a junior fee earner or a trainee uploading documents into ChatGPT, you are the one responsible for their actions. Let that sink in for a moment. Do you know how documents are being created when you're asking a trainee to create a document? Because if you don't know how that document is being created, how much information has been put into an AI search engine or an AI machine to analyze what they've been asked to do, provide that outcome within personal information for that customer, you're the one who's next on the block, not the hapless trainee, because you're expected to know what your handlers are doing. It's the whole point of supervision within law firms. So beware, that is a major issue. The regulator's answer here is that closed tools that never go public carry none of this risk. So the tribunal pointed to closed source AI as the safe route for tasks like summarizing. Okay. And again, summarizing is one of those key areas that we're seeing that handlers are actually utilizing AI for, where they're uploading the information and asking for a summary. Speed it up, take this 4-page, 10-page, 12-page document and reduce it down to 2 paragraphs for me. Give me that summary. Now, closed AI, what does that look like? It's very basic. That could be Copilot. And I say could be because you need to check with your IT team that Copilot is shut down in the right way so that only certain people have access to only certain elements within Copilot. So you can open up different areas of Copilot within your licensing for different teams. So for instance, you might be a multidisciplinary law firm. You might have Chinese walls where you've got one side deals with claimant work and one side deals with descendant work. And you can close those barriers down so that neither side can have access to the other parts of the company. That's a really powerful tool within Copilot. And because of the licensing you pay to Microsoft, that's there and available. But there are buttons there that you must tick. And I stress this for the IT team, because if they're not aware of what's being asked of by certain areas, and therefore it's not shut down, Copilot is no different than any of the others. When it's going outbound to a large language model with personal information by the customer, you are creating that risk. Okay, so be aware, all right, and look for closed tools. I will talk about what we do at the end, but that is a really important point. It's already been approved by the court that you can provide this as a shutdown. It's not a problem, but you've got to be aware of where those situations are within Copilot that you can shut everything down. This is the scary bit for me. What does the breach actually trigger? Right. The number one bit is you've got to go and self-report to the SRA because it's a breach of the confidentiality element, and therefore the retainer's been breached the moment the data leaves the law firm. So as soon as somebody uploads any document with any personal information for customers, that's it, boom. You now need to go knocking on the SRA's door as soon as you find out about it. The second point is what I've stressed already, and some people forget about this point. You've essentially made a privileged document public. And if you do that, it's lost its protection for good. So if you're in the middle of a complicated claim and you disclose a document that's related to that claim into Copilot, or rather ChatGPT or OpenAI or Claude or any of those AI systems, if it is not shut down, like I said with Copilot, then you are in a position here where that privilege has gone. And then as soon as you know it, you've got to go telling the SRA. And that's the SRA from the law firm point of view to say, we have breached our retainer, we've breached the SRA principles, we've done this, or we've allowed this to happen, or this has happened by mistake. And that in turn has created all these problems. So beware. If any handlers are not aware of what the implications are, you need to show them this and say to them, do not do it. Do not upload any information that's personable to that customer, whether that's in a letter, whether it's part of data within an Excel sheet that you might be looking to analyze trends, etc. You're in a pickle if you've done this. So one of the companies that had to go through this is Pinsent Masons. And this is the really recent handing down of the case from last month. It's really hard to talk about it in a critical way because Pinsent Masons protected the handler, the junior handler, because the supervisor knew that the handler on occasion was using AI. So there's an element here where it's a learning tool for us all without us being critical about what Pinsent Masons did. Because when you hear this story, you might have a bit of a, oh my God, is this happening to us point? Because Pinsent Masons are doing something that's been going on now for months with lots of different firms. They've said to handlers, oh yeah, if you want to use AI to speed you up, not a problem. Not then narrowing that definition down to you can only use Copilot because the IT team shut it down. You can't use Claude, you can't use ChatGPT, you can't use OpenAI, you can't use Gemini. All of these AI products you can't use. But if you don't communicate that, then the junior handler that uploads something then creates a problem for their supervisor and then ultimately the partner in charge. And what happened here was there was an application being made and the AI had completely hallucinated in relation to that application and started quoting regulations that were wrong, just plainly wrong. And when it landed before the judge queried this. I was like, I don't think that's what these regulations actually state, and pushed it back. When it then landed back at Pinsent Masons, the handler dealing with that then essentially put the judge's communication into the same engine with the same original information, and it then responded back to the judge. So essentially, the file handler had done no investigation of this. It was merely probably a pressured situation where they're trying to deal with things as quickly as they can. They've thought AI did this in the first place. AI can respond to the judge. And that's what happened. And as a result, that's where the judges said, look, you completely outsourced the thinking process here. And you kind of go, well, isn't that the purpose of AI? And I would argue, no, that's not the purpose of AI. The purpose of AI is to make the human in the loop more efficient, more knowledgeable, and being able to respond quicker without the kind of drudgery of admin stuff that the AI can assist with. So there is a massive benefit of it to AI with the human in the loop, but at the moment, without that human in the loop, it's a massive risk. So as I said, the AI rule that the AI had cited says nothing at all what it was trying to say. It said And the judge just blew this out completely. Now, and this is what I stressed here, Pinsent Masons knew what was going on. They didn't realise properly the implications of what was happening. And there's a point here where this is about hallucination as opposed to data breach, because there's not an argument here in relation to a disclosure of personal information. The issue here is that the supervising lawyer was aware that the junior handler was using AI from time to time, but was unaware that AI was being used specifically in relation to this application. Now, this is where, as Chris and I have been developing an AI product, it's really easy to see how you can go from one step to the next to let the AI develop the application, because we've got to a position where the AI can generate witness statements in the claimant's own words by uploading telephone notes, attendance notes, inbound communication from customers that will be used to form that witness statement that does it in the claimant's own language. And you kind of go, well, you know, that's similar, isn't it? You're creating a witness statement. And yes, but that's for the human in the loop to check and make sure it applies to everything that's being claimed for or everything that's being defended. And there's a supervision tool within the product that does that assessment and kind of gives you a red, amber, green as to whether or not it deals with the majority, all of, or missing some key information. The point here is that the application was being run by the individual without that supervision of the actual individual application. And you could go, is that a failing? But, you know, ultimately, we employ people to be able to do a job. And if this is a supervisor, if this is a solicitor who understands how to make an application, you would hope that they wouldn't just make an application and send it on its way, that there would be some checking of what's going on. So when you kind of back this up, the 3 failure modes every busy claims desk shares is that you're trying to do this generation without verification. So an AI module produces authority that sounds real, but isn't. And it comes across in a confident, fluent language that convinces you, actually, oh, this has got to be right. You know, look at this. Section 51 of the County Courts Act, and this is what it says, and this is how it should be interpreted. Great, but actually that might be a complete and loads of codswallop, as was what's happened in the Pinsent Masons case. So you've got to kind of push this bit through on this generation, yes, to speed you up, but the supervision then needs to really kick in. And then you're in this position of, well, the reviewers see the output, never the AI behind it. So that check then happens too late, because if you just scan over its application, it probably looks right. And then you're in this position then where what happens with the cover-up. So when it goes wrong, the temptation is to retrofit an explanation. No trail, no defense. So, you know, claims desks, we've all been there. We've all sat there. We have 30 outstanding tasks to do. You know, on a Monday, by the time you get to Friday, it's 50 outstanding tasks to do. I've got to generate these applications. I've got to generate witness statements, etc., etc., etc. It's dead easy to kind of go, oh, well, AI is giving me a quick response. I'll just push it through, forgetting that AI isn't. You're putting it into an AI product that might not be locked down. You might be sharing personal information, but more importantly, and this is even where Copilot fails, it's about the boundaries that AI can go to. So again, one of the things that's been really a real positive learning tool for us over the last few months is how to create the strong box. Because if you've got walls that dictate you can't look anywhere else outside of these walls, the AI becomes even more powerful. It means it can't hallucinate. It means it can't misquote cases, or worse, make cases up. And so whether you come to us in the future and we talk about LegalDocs Assist, or you're doing something yourself, you know, to creating that strong box is exactly where you can protect to ensure that hallucinations don't happen. So the operational reality, what this actually means for a claims handler. You're in this position of kind of going, one paste and it's done. It's as easy as that. I can just cut and paste, or I can upload this document, or I can get through this position of kind of going, yeah, all I have to do is rely on AI, and all of a sudden the expectation, old school, deliver 5 hours of fee earning time every day, all of a sudden then kind of goes, oh yeah, I've been able to do that. I've been able to push this through, tick it off, get it off my desk on a normal Tuesday. And if you're in that mindset, because the supervision above that has not been saying AI is a tool, there are parameters, and you need to stay in these parameters, this is where this could fall down for you as a business. So if you take nothing else away from this webinar, take one thing away now, and that is to go and ask each handler that's in your team, what do you use AI for? And I'll leave that as a really powerful place to go, because as soon as they say, oh, I upload these letters, your alarm bells should be going off. Where are you uploading them to? Copilot, IT team. Is that handler got Copilot absolutely nailed down so that we can't lose any of that? And what large language model is Copilot looking at in order to support that handler in their responses? If it's just going out to the internet and giving them a response, be prepared for those hallucinations. Handler says, yeah, I just uploaded to ChatGPT. Your proper alarm bells should be going off. Yeah. Any personal information on that documentation that's being uploaded to ChatGPT to summarize, review, create a response, draft an application, it should be a massive, massive red alert going off. What's our license with ChatGPT? That applies to them all. Okay, so please take that away from today. If you take nothing else away. And this is exactly why, because that accountability stays with you in the firm. You can never say, oh, it's ChatGPT that was wrong. They're the ones that should be paying this fine, paying these costs, dealing with this complaint, etc., etc., etc. I wouldn't like you to have sat through this half an hour and at the end of it go, oh my word, it's not a problem for us because the chatbot's responsible. It is not. The accountability stays with you. So here we go. The single most important action is to train every fee earner. All right. You've got to provide this training to them, whether that's through us and watching this as a CPD webinar, or it's side by side, or it's delivering as a team into what should be done from the IT department, because most firms underestimate how widely public AI is already in use. Assume it is. Can't stress that enough. Assume it is already being used by your handlers. Look for productivity measures. That's a really key giveaway. Have their productivity measures gone up? Because then you're absolutely guaranteed they're using it. But assume it anyway. But train them, set the policy around it, and give people a closed default. Whether that's through Copilot, with your Strongbox, explaining that this is what's going to happen, or looking at tools like ours, which keep it closed, which means that your data is protected and your answers are only ever given based on what is available in that Strongbox, not what's available worldwide. So I mentioned Copilot. And I always think on webinars, you don't want to sit in and get a sales pitch. Most of you will be using Copilot anyway. Check with your IT team that you've got the permissions set properly so that no personal data can be escaped through Copilot. But think about how Copilot might still be giving you hallucinations. Otherwise, this is the sales pitch. A closed product looks like ours. We're already working with claimant law firms across the UK. It creates court-ready legal documents for RTA, ELPL, housing disrepair and click neg claims. All right, it's amazing. It blows my socks off all the time as to the support it gives your handlers. Most importantly, it's the human in the loop review. So you're in this position where you can drag and drop information in, you can ask simple questions. It will give you a full audit trail of, essentially where that information has been gleaned from, and different parts of the product deliver different elements. So you might get a copy and paste response back. We can download Word documents to create as witness statements, etc. And the best of it is we'll even give you a free trial. So if it is something that you're interested in, then do reach out, because we'd love to get you a free trial up and running so that you can see the impact it can have on taking the administration elements away that provides you as the human in the loop a swifter, more efficient, more reliable outcome. Because it is a closed platform. Everything that I've said to you about hallucinations, we have 3 checks in there that will stop it hallucinating, or 3 barriers that it's got to go through to ensure that hallucination doesn't happen. Extrally, with clinical negligence claims, it turns the disorganized records into a paginated index bundle and pulls comparisons between medical reports and medical records. In the EL and PL area, we talk about protocol compliant letters of claim for EL and PL, drafted and ready for a fee and a review. And in HDR, we pulled together chronologies and documents built to the same standard on the same closed platform, with witness statements being able to be created through all areas in the witness's own names, and obviously fully court compliant with CPR 32 in England and Wales. But we're also available in Scotland and Northern Ireland, and we're working on a worldwide product for other areas around the world. We'd love to have you on board giving it a go, because we have that confidence that it is a closed platform and workable for you guys. Just stress that again, that it is that human in the loop by default. And most importantly, the closed source environment stops the hallucinations. So there you go. We'd love to see you on board. Otherwise, thanks for spending this half an hour with me. This will be up on our website so that you can share it with colleagues along the way. But ultimately, do bear all those points in mind. Don't assume, first of all, that everybody's using AI. Make sure that you've got them trained to understand the implications of what happens when AI goes wrong. Appreciate your time. Take care. See you all soon.
It's not letting me stop.
Let's leave it. It'll stop automatically.
It's all right. Gone.